There's a person on the line with no name. It says just iPhone. Would you turn on your camera, please? The one that says
Yeah.
Samsung. Would you turn on your camera also, please?
All right.
Okay, that's you, Carlos. All right. Just want to make sure who it is. Whoever has a Samsung phone, would you please turn on your camera? Anybody call for any witnesses? No. Whoever has a Samsung phone, turn on your camera, or you will be disconnected. Okay, Ruel. All right. Just want to make sure who it was.
Yes, sir.
Okay, good afternoon, everybody. Today is Tuesday, October the 8th. My name is Judge Esponza. We have some writ hearings scheduled for this afternoon. The defendants are present in the courtroom. They have been sworn in. I believe they all speak English. You speak English, ma'am? Yes, they all speak English. So we'll go ahead and get started. Alejandra, thank you for being here.
Good afternoon, Your Honor.
The first case we're going to call is C 4603-24-F, State of Texas versus Demi Alejandro. So Alejandro, go ahead and stand up here in the middle. You weren't here earlier. Stand in the middle of the room, a little bit further back, so that you can see yourself on the TV. I need to swear. Raise your right hand. You swear to tell the truth, the whole truth, nothing but the truth, so help you God? There you go. Robert Handy, this is your motion, sir. You may proceed.
Yes, Your Honor. Good afternoon. Your Honor, I'm here, of course, for a bond reduction hearing for Ms. Alejandro. Of course, it is difficult for her to pay the bond currently where it stands. Her family cannot pay as well. Regarding her background, Your Honor, she is a U.S. citizen. She is from the Valley, primarily from Edinburgh. She is a Cairo Meade high school graduate. And of course, she is indigent, and she's been incarcerated for, I believe, 9 days of a total bond of $11,650. Regarding further ties to the Valley, Your Honor, she does primarily live with her boyfriend's family, including also taking care of the boyfriend's son, excuse me, his parents and grandmother, and she gets at most about $50 a week to take care of them. But primarily, she's not working, Your Honor. She is working on her GED with one more class left to graduate, and she does plan on going to STC to work for a medical office specialist. But it is her goal to be an anesthesiologist and get transferred over to UTRGV with that. And of course, she also has pet responsibilities as well. No priors and no current violent crime, alleged violent crime. But given these factors, Your Honor, if released, she would be under the living with her boyfriend's family. Would ask, of course, for if at all possible, if we'd bring an agreement for at least $1,000 PR bond in her case, as being sufficient and reasonable for her to to make an appearance without it being oppressive. So any consideration would be appropriate, would be appreciated, Your Honor. And I do have Ms. Alejandro's contact information if needed, Your Honor.
All right. What says the state?
Yes, Your Honor. In this case, we are unopposed to a PR bond with the condition that she obtain a drug patch. The defendant doesn't have any criminal history. However, she does have a few POMs pending, Your Honor. So we would be asking for a PR bond with the drug patch.
So she doesn't have any convictions, but she's been arrested multiple times, though, right?
That's correct, Your Honor. She was arrested once in 2020 for a POM, and then in February of 2022, then again in February 25th of 2024, as well as a resisting arrest from September 2024, Your Honor.
Like you didn't hear, man? Keep coming back. You were out on bond, you got arrested again. Is that pretty funny to you?
No.
You can sit there and laugh, go back to your cell and laugh the rest of the day. You want to do that? Who do you live with?
My boyfriend's family.
Want to order monthly UAs probation's gonna contact you to go in and get drug tested. The first time you come back positive for drugs or alcohol, you're coming back to jail and you're gonna stay there until you go to court. You understand? The verification, right? The $5,000 bond?
I believe that's, yep, sorry, Ms. Robledo, sorry about that.
Sorry, Robert, go ahead.
Yeah, that's
That's
correct.
That's the only thing before me. The other ones have PR bonds or case numbers. So the only thing before the court is the verification. I reduce it to $1,000 cash surety. Up to you is. Better stay clean and come back again. You're gonna stay in jail. You understand me? Anything else, Robert?
That should be it, Your Honor. If I may be excused before this honorable court, Judge,
Yes,
and
sir. Thank you.
y'all have a great day.
Have a good
Thank you.
afternoon.
You too.
Yeah.
All right, bye-bye.
Shouldn't be excused. The next case we're gonna call 4600-24-I, State of Texas versus Joseph Banasak.
Good morning, Your Honor. Jorge Ortegon, Basnack, Judge.
Good afternoon.
Your Honor.
You may proceed.
Judge, my client is being held. He is a U.S. citizen, Judge. He has no means of income. He resides in Palm View, Texas, Judge. He's being held on a $10,000 bond for assault impeding, Judge, which is well beyond his financial means. Unfortunately, Judge, he was appointed an attorney prior to me, but there was no actual appointment. So he has now been sitting in jail for about 23 days, Your Honor. His other case, which may have already been filed, I'm assuming it probably has a $4,000 bond, Judge, which we obviously, it's a misdemeanor. We may not have any authority over that, Judge. We are respectfully requesting any consideration so he can make bond at this time, Judge. Maybe $1,000 cash surety. Obviously, as this court knows, if the misdemeanor has been filed, he still has to come up with at least $400 to get out on that, Judge. So he is looking at substantial bonds, which are well beyond his financial means. As this court knows, he is presumed innocent unless proven guilty, Judge. Again, he has been incarcerated since a couple days before September 25th. And we're finally here to have him heard today on October 8th, Your Honor, with those bonds being too high for him and his family, Judge.
Alejandra, says the state.
Yes, Your Honor. In this case, the state would recommend no reduction, that the bond stay at $10,000 cash surety. The allegations are pretty serious, Your Honor. The defendants allegedly strangled his girlfriend, punched her in the face, pulled her hair, body slammed her. At that point, he also choked her to where she says that she passed out for 20 minutes. When she tried to call for help, he took her phone and smashed it. That's where the criminal mischief comes from. He recently did 6 months state jail on a terror threat to a peace officer and has one previous assault on the same victim. So we would recommend no reduction, Your Honor.
Banasak, how old are you, sir? How old? How old are you, sir? I'm asking the questions here, not you. How old are you, sir? Okay, I'm asking the questions, not you, okay?
I'm not asking a question, I'm asking for help.
Sit down. Recall it, Carlos. Bond's gonna stay the same. I read the report. There were serious allegations, as the state indicated. He was recently released from state jail where he did time for a terroristic threat. As the state indicated, he has a prior assault charges on this individual, same victim. Bond, in my opinion, is reasonable and for the safety of the community. Bond will remain at $10,000 cash surety.
May I be excused, Your Honor? Thank you.
The complaint has been filed on a criminal trespass, so I don't have any jurisdiction on it.
Thank you, Judge. May I be excused, Your Honor?
Yes, sir. Thank you. The next case we're going to call is C 4618-24-C, State of Texas versus Jorge Maldonado. You speak English, correct, sir? Sir. Carlos, this is your motion. You may
Yes, sir.
proceed.
Yes, sir. Thank you. Mr. Maldonado, I spoke with him a few days ago. He informed me the only prior he's got is a possession of marijuana. And he hasn't been to prison. He's a green card holder, resident, self-employed. And, you know, this crime is sort of character because of somebody not having a religious criminal history. The charge is aggravated robbery with a knife. He went in and with a store with a knife, and that's the aggravated robbery. Judge, I don't have my notes in front of me. And over here in the 430th, I left my notes at the office. I don't remember what his bond is, but it's very, very high, and we'd like some sort of reduction.
It's at 150,000.
150? Yeah.
Yeah, I didn't see an ISO on it. Did you see an ISO on it?
Judge, let me look into it. No, he has no ISIL, Judge.
No, I didn't think so. Okay, what says the state?
Judge, in this case, we would recommend a 75,000 cash surety bond with a drug patch. As defense counsel said, it is alleged that this defendant went into a convenience store and robbed the cashier with a kitchen knife. He later did confess to the crime and stated that that was due to his addiction to crack cocaine, which is why we're asking for the drug patch, Your Honor.
Well, I would certainly agree with that.
I was staying with my aunt,
What city?
Edinburgh, Texas.
How old are you?
I'm 26 years old.
Do you have a job?
Yes, sir.
Where do you work?
I have my own painting company.
You have a what?
Painting company.
Your own company?
Yes, sir.
Were you painting houses or what?
Yeah, painting houses.
Do you have status here in the United States? You weren't born in the United States, right?
No, sir. I have a resident, permanent resident.
Okay. So you have a drug problem?
Yes, sir.
If you make bond, I'm gonna ask that you be released to AIP officials, which means you're gonna be under house arrest. You'll be allowed to go work, but you need to notify them where you're gonna go. You need to give them an address. They're gonna go check. If you're supposed to be working somewhere, that's where you need to be. If you're supposed to be home, you need to be at home because they'll go check. The first time you violate the rules of house arrest, they'll notify the court and you're gonna end up back in jail. Do you understand that?
Yes, sir.
They're gonna come and visit you before you're released. They're gonna give you a contract with all the rules. No weapons, no drugs, don't get arrested. There's about 20 rules in there. Make sure you read them before you sign it, because you're gonna be responsible for following those rules. You don't follow them, you're gonna end up back in jail. Is that clear?
Yes, sir.
Also gonna order monthly UAs. Probation's gonna test you. I'm gonna put weekly, actually, every week. Make sure you put weekly. They're gonna test you every week. The first time you come back positive for drugs or alcohol, you're gonna sit back in jail. Get yourself some help. Go check yourself in somewhere, get some help. You know, if it's that bad. Don't go back to that location. Understand? The stripes or whatever it is, don't go back there. Bond will be reduced to $25,000 cash surety.
Thank you, Judge.
Thank you, Your Honor.
All right, good luck. Anything else? Carlos?
That's all I have, Your Honor.
All right, thank you.
Thank you, Judge.
Next case we're gonna call is C 4592-24-I, State of Texas versus Alexis Pettis. You speak English, correct, Mr. Pettis? Go ahead, let's get it. You're on mute.
Yes, sir. How you doing today, Judge?
Good, good. May proceed.
Okay, Judge, I filed this writ in an effort to try and reduce the bond. It's presently set at 30,000. Mr. Pettis is a U.S. citizen. He's from the Mission Palmview area. He's got a family of 6 that he helps support. We're asked the court to consider reducing it to a reasonable amount, perhaps $5,000 or $10,000, Judge.
Judge,
DWI third, right?
Yes, sir.
What says the state?
Your Honor, in this case, we would recommend no reduction. The allegations are, Judge, that this defendant was pulled over for a traffic stop. He admitted that he had been drinking at the party. Additionally, SFSTs were conducted. He later blew a .10. In looking at his criminal history, Your Honor, he looks like he has a pending cocaine charge out of the F court, as well as the previous DWI third was from 2021. And then as well as multiple drug offenses, Your Honor. The DWI second was in 2020. And the first DWI was in 2019. So we are looking at an individual that commits this offense pretty frequently. We would recommend no reduction.
Mr. Pettis, you have a job, sir?
Sir,
Where do you work?
mechanic,
Who do you work for?
my stepdad, he owns his own shop
Where at?
and, Palmview. La Homa.
House or where does he work at?
La Homa. But I think it's 3415 North La Homa Road, something like that.
Are you on parole or probation right now?
Bro,
You're on parole, right? You just got out?
yes, sir.
When did you get out?
March 13th,
This year?
yes, sir.
You're on parole till when?
Discharged in January.
He's got a parole hold, Will. Was parole
Well,
spoken to you?
I was discussing that issue with with Mr. Pettis. And, we believe we can work around that, if we approach it delicately.
You understand there's a parole hold on you, correct? You know that?
Um,
Which means parole, even if you make bond, you're not gonna be released until parole lifts that hold. And I don't know if they will or not. You're out on parole for DWI, correct? And you picked up another one.
but my parents DWI was
I don't wanna go over the facts. I'm just telling you what's in the report. I didn't see that the magistrate ordered any type of interlock device or portable. So I'm going to, if you do make bond and get out, I'm gonna order that you get a portable device. Tell Adrian to prepare portable for this individual. You'll have 5 days, once you're released, to get that portable device, and you're gonna have to blow on it 7 days a week, 3 times a day, between 8 and 6 in the morning, between 4 and 6 in the afternoon, and between 9 and midnight every single day. You miss one time, you're coming back to jail. I don't want to hear any excuses that the battery was dead or there was no signal. You miss one time and you're coming back to jail. Do you understand me?
I told him to not do it.
Yeah, well, do you have a vehicle?
not really, sir.
No. Yeah, go ahead and have him do it.
Okay, he's doing it.
The magistrate actually ordered a ignition interlock, but I'm gonna have him get a portable, in the alternative. And I want him tested every single day. And the first time he comes back positive or he misses, he's coming back to jail. I'm also gonna order that you be under release to AIP officials. If you are released, which means you'll be under house arrest, you say you have a job, you tell them where you're working, they'll go verify that you're working there. If you're not there when you're supposed to be working, or if you're not at home when you're supposed to be working, they're gonna notify me and you're gonna come back to jail. Is that clear? I'm also gonna order, a curfew. You need to be at home between the hours of 9 PM and 6 AM, Monday, 7 days a week. So no going out anywhere. You're at home at 9 o'clock, no later than 9, and don't leave the house before 6 AM. You understand?
Perfect place to print.
I'll be reduced to $15,000 cash surety.
What was that amount, Judge?
15,000 cash surety. With all other conditions. Anything else, Rod?
That's all we have, Judge. May I be excused?
Yes, sir. Thank you.
Thank
Good
you.
luck to you, sir. Make sure you comply. Next case we're gonna call is C4556-24-E, State of Texas versus Joshua Pina. Speak English, sir? Juan Tijerina, your client is present, sir.
Good
You may
afternoon,
proceed.
Judge. Thank you, Your Honor.
Good afternoon.
Judge, we're here before this honorable court, Your Honor, on a writ to reduce bond. My client is being charged with stalking, Your Honor, and the bond at this time is rather egregious. It's $500,000 for a stalking charge. My client is a U.S. citizen, Your Honor. He's 30 years of age. He's been employed at VIX Auto Body. He also has 4 children that he provides for financially. And if the court would to reduce his bond, Your Honor, or he has been in the county for 25 years, Judge. Again, he is a U.S. citizen, but was born up in Tarrant County. If the court was to reduce his bond, he would live with his mother in FAR. Just for the court's information, I'm asking the court at this time for consideration of a $2,500 cash or surety bond for this case.
What says the state?
Your Honor, in this case, we would recommend no reduction. The facts of the case, Your Honor, is that on September 19th, the defendant was seen going to the victim's employment, where he then texted her from an account that she would use to communicate with his mother regarding her children. The defendant had just been released from county judge on an assault case where he assaulted the victim's new boyfriend. There's also different reports that the defendant had entered the victim's residence and assaulted the boyfriend. I believe that's where the assault stems out of. That the defendant had tampered with the victim's vehicle, that the defendant had threatened to kill the victim and her new boyfriend, Michael, that the defendant had put sugar in the victim's gas tank, that the defendant was harassing the victim, and that the defendant stole the victim's iPad. Your Honor, I believe that this continuing course of conduct that the defendant exhibits against this victim is very concerning and very alarming. We would ask that you leave the bond as is at $500,000 cash surety.
The magistrate who arraigned him issued a protective order, which means, Mr. Pena, that you're not to have any contact with the protected person, which is Victoria. She your ex-wife?
Yes, sir.
Were you all married or you still married?
I guess you can say common law.
Okay. Well, you're not to have any contact with her, sir. And I don't know if that was the case already, if there was a prior protective order, but there was one issued on September the 20th by the municipal court out of McAllen. It's effective all the way until November 20th of this year. I'm going to ask that you have no contact whatsoever with the victim or the children involved until this case is resolved. If you can go, Juan, is there a family law case opened up on this? Do you know? Are you retained on any of that?
No, Your Honor, not to my knowledge, Judge. I was just retained on this writ for the bond reduction.
Okay. I don't know if there's any type of visitation order, but if there is, I'm going to ask that it be executed at what city do you live in? What city do the children live in? Yeah, I think Fire Police Department has a place out in front where you can exchange students, not students, but children, if there's an order in place. I'm not saying you do it, only if there's an order that says you have rights for visitation, then you can execute it there at the police department. Otherwise, I don't want you seeing these children or the victim until this case is resolved. Do you understand me?
Yes, sir.
No more calls, no more text messages, nothing, no more communication. Is that clear?
Yes, sir.
How old are you, sir? You own any weapons?
No,
Guns in your home,
no, sir.
in your mom's house?
No, sir. No.
If there are, you need to get them out of there. I'm gonna have probation go over and check. If that's where you're going, I'm gonna have probation go check. If you find any weapons there, whether they're yours or not, bullets or weapons, I'm gonna put you back in jail. So you tell your mom or wherever you're going to stay, you need to clean that house out before you go there. You understand me?
Yes, sir, I understand.
Any other conditions you want imposed, Alejandra?
Your Honor, he does have a POCS, penalty group 1, pending. I would ask that he also obtain a drug patch.
I'm gonna order weekly UAs. You have to go in once a week, sir, to get drug tested. No drugs, no alcohol. The first time you don't show up, the first time you come out positive, you're gonna come back to jail. Is that clear?
Yes, sir, sir.
Bond will be reduced to $50,000 cash surety. Anything else, Mr. Tejeda?
No, Your Honor. Thank you for your consideration, Judge.
All right, sir. Good luck to you.
Have a good day, Judge. Thank you.
You too. Thank you. I believe that's everybody. Alejandra, thank you for your help.
Yes, thank you, Judge. It was an honor to be before you today.
Have a good afternoon.
You too, Judge. Thank you. Bye-bye.